single day.
Pleaded guilty and served out his. In June, the U.S. Supreme Court granted IJ's petition in Timms v. Indiana, a case that will make constitutional history. Tomorrow, we will present argument before the justices. Today, I want to talk with you about this case and its role in IJ's property rights litigation. IJ filed our petition on behalf of Tyson Timms. Tyson is a young man who is overcoming opioid addiction. After he was convicted of selling $225 worth of drugs to undercover officers, a mistake he made in a last-ditch effort to fund his addiction, Tyson pleaded guilty and served out his sentence, which included house arrest, probation, attending AA meetings, and maintaining a steady job, as well as paying $1,200 in fees. But rather than let Tyson get his life back on track, the government made his recovery all the more difficult by using civil forfeiture to seize his only vehicle, a truck he bought with the proceeds of a small inheritance. Needless to say, this case is very important to Tyson, but it will have implications for all Americans. There are three vital issues at stake in Timms v. Indiana. First, Timms presents an essential but unresolved question concerning a key protection in the Bill of Rights, the Eighth Amendment's prohibition on excessive fines. Over the past century, the Supreme Court has held that virtually all the provisions in the Bill of Rights are applicable not only to the federal government, but to state and local governments as well. Remarkably, the court has never directly held that the Eighth Amendment's excessive fines provision is incorporated against the states. The Timms case will resolve that issue for the first time. Second, this case arises in the context of an issue that IJ has pioneered and one in which we have revolutionized the law: civil forfeiture. As you know, civil forfeiture allows the government to take your vehicle, your cash, even your home or business, regardless of whether you were convicted or even charged with a crime. It is one of the greatest threats to private property rights in America today. And even where civil forfeiture is somewhat tied to illegal activity, like in Tyson's case, forfeitures sought by the government are often far more draconian than the criminal penalties imposed. Indeed, the trial judge in Tyson's case called the forfeiture of his truck grossly disproportional to his first-time offense. Justice Clarence Thomas recently declared that it was time for the Supreme Court to revisit the constitutionality of civil forfeiture statutes. This case provides the court its first opportunity in over 20 years to re-examine this doctrine. Finally, Tyson's experience spotlights many of the injustices that flow from excessive fines, fees, and forfeitures. You may remember IJ cases in Missouri, California, Georgia, Indiana, and elsewhere on behalf of property owners who receive thousands of dollars in fines from minor code infractions like chip paint or cracked driveways. There is no public health or safety justification for this enforcement, just a desire for revenue on the part of government agencies that stand to financially benefit. These perverse incentives have created a nationwide phenomenon. At the federal, state, and local levels, fines, fees, and forfeitures have exploded as governments turn to economic sanctions to bolster their budgets. The Timms case has the potential to protect individuals in every state from these abuses and to limit government's ability to turn law enforcement into a revenue stream. For all these reasons, IJ knew that we had to take and win Tyson's case. As you reflect on the case and its potential impact, it is important to recognize that IJ did not just seize this opportunity, we created it. This moment at the Supreme Court is the result of the foundation IJ built on the dozens of cases we litigated on these issues, the path-breaking strategic research we produced, the legislative solutions we developed, and the scorching exposés we secured in the nation's most influential media outlets. And this case, in turn, will be a building block to still further victories in the defense of vital constitutional rights. On behalf of the Institute for Justice and the courageous clients we represent, thank you for making it possible.
The Institute
for Justice.
The National Law Firm for Liberty.
Welcome to Indiana News Desk. I'm Joe Wren. And Indiana law allows police to seize thousands of dollars worth of property if they think it's involved in a suspected crime, regardless of whether the person who owns it is ever convicted. The country's highest court is set to hear a challenge to one aspect of that civil forfeiture law later this year. Reporter Barbara Brozier joins us now. Barbara, what's this case all about?
Well, a Marion resident named Tyson Timms claims police violated the Eighth Amendment's excessive fines clause when they seized his vehicle worth more than $40,000 because he used it to transport a few $100s worth of drugs. The case will go before the U.S. Supreme Court this fall, and while it started as an attempt to get his vehicle back, Timms says it's now about something bigger. The driveway where Tyson Timms lives sits empty.
It might sound silly, but it hurts my self-esteem. I'm a grown man that doesn't have his own vehicle.
Timms did have a vehicle 5 years ago. He used more than $42,000 in life insurance payments after his father died to buy a Land Rover. Police say he drove that car between Marion and Richmond several times in 2013 to buy or sell heroin. It was something Timms says he did out of necessity to fuel his own addiction.
I had ran out of my life insurance money, and I didn't want to be sick. You know, I had a little bit one day, and a guy called and said, hey, I have some people that, you know, want to buy some dope, and I took the chance.
But one of the buyers ended up being an undercover detective. Court documents say Timms sold heroin to police at least twice for a total of about $500. Police later arrested Timms and also took his Land Rover.
I was angry for a while. You know, to be honest, that probably got me through a long time, was anger and hatred. I hated the police for what they did to me, and I was going to show them, you know, I assumed that they probably expected me to fail.
While Timms pleaded guilty to 2 felony charges in his criminal case, he challenged the civil forfeiture. Timms doesn't think police should be able to take a car worth tens of thousands of dollars for a low-level drug offense. His attorney argues that violates the Eighth Amendment's excessive fines clause. The trial court ruled in Timms's favor, saying the vehicle was worth more than 4 times the maximum penalty he could face in criminal court. And the Indiana Court of Appeals also sided with Timms, saying the seizure was disproportionate to the gravity of the crime. But the Indiana Supreme Court took a different position.
The Indiana Supreme Court took the state's appeal and decided, to everyone's surprise, that the excessive fines clause of the U.S. Constitution does not apply in this state, meaning that the state could take Tyson's vehicle, and meaning, in fact, that the state could take any user's property for even a minor crime.
That's something the U.S. Supreme Court will now have to decide after it hears the case later this year. But most civil forfeiture cases don't get nearly as far. It's hard to put an exact number on how many cases go undisputed because until this year, the state didn't require counties to report those activities. But experts say, more often than not, the seizures go unchallenged.
If you seize $1,000, but it costs you $3,000 to get it back, nobody in their right mind is going to fight. They're going to give up.
And that's not the only barrier for Hoosiers who want their property back. The seizures are handled separately from criminal proceedings in civil court. That means there's no right to an appointed attorney if a defendant can't afford one.
And that's a very troubling notion, that people are losing their property, not because they're guilty of some illegal activity, but because it's either too costly or too difficult
Hearing those kinds of stories is what motivates Tims to continue his fight.
It's not about getting my truck back, you know, for me. That hasn't been the case for me for a long time. For me, this is principle. You know, they shouldn't be able to do this to people.
In the years since police took his car, Tim says he's made a lot of changes. He's now clean and even speaks to local and state task forces about his battle with addiction and the criminal justice system. And he has a job, but he has to borrow his Aunt Wendy's car to get there while she takes the bus to dialysis.
We don't all have an Aunt Wendy, so there's a lot of people like me that they're stuck.
It's those people Tim says he'll be thinking of as the Supreme Court hears his case.
The court will hear that case in November or December of this year, and it's one of several legal challenges to Indiana's civil forfeiture laws. Next week, we'll take a closer look at where the money goes when property is seized and sold, and why some argue that violates state law.
I sold a couple $100 worth of dope to the cops. Nobody got hurt. They never arrested one person that said they got drugs from me, because there isn't anyone. I was an addict. The issue that I see is people look at this like, okay, he committed a crime, they took his truck, he's punished. Okay, you can look at it like that, but what about everything that comes with it? You want me to rehabilitate myself. Well, how am I supposed to do that? Okay, I need to go to meetings. I need to, go to the counseling and therapy that I do. I need to get a job. I need to meet with probation. When I wasn't working, I was tutoring people who were getting their GEDs. How am I supposed to do all this stuff if I don't have a way to get around? I was over my truck. I was pretty sure I wasn't getting that back, and it wasn't about that for me anymore. It was principle after that, because it wasn't right, especially after I saw that it wasn't just me. Even in this small little area, I found dozens of cases where they took people's stuff. I was gonna at least see what I could do. I wasn't gonna I couldn't just stop.
Civil forfeiture is one of the greatest threats to property rights in America today. It allows police and prosecutors to take property from people without even convicting them of a crime. Many people, the vast majority of people who suffer from civil forfeiture have never been convicted of a crime. This is the only state in the nation where prosecutions for civil forfeiture can be outsourced to private law firms who then work on contingency based on how much property they forfeit. Tyson's case, this very case, was brought by a private law firm working on contingency. And we have to ask ourselves if these types of cases would even be brought if the prosecutor wasn't financially self-interested.
Really, this is an interesting commentary on the system as much as anything. The Supreme Court does need to look at this issue. We had argued that maybe they should wait for a better case, but they need to look at the issue. And they need us to argue against incorporation for them to be able to decide it. If we didn't make that argument, they would never have occasion to make the decision. And so that's as part of the system that we're in and part of the role that we play as much as anything. I think most people you would talk to who are knowledgeable about this issue would say we've got an uphill road here. You play the hand you're dealt. We are realistic about our chances, but we think we've got some powerful arguments to make.
I joked about this in the beginning, and I told people, I'd like to figure out a way to try and change a law or something, to do with this. So that's the reason that I haven't given up. If I can maybe make a difference, help somebody in my situation, it's going to be worth it.
Charlotte County Sheriff Bill Prummell is one of those thieves that brags about stealing people's shit through UN constitutional forfeiture and seizure. Lucrative law enforcement will become lawless. Tyson Tims made a mistake, but not one as important as Indiana's Supreme Court made in allowing to stand the punishment the state inflicted on him. He was a drug addict first with opioids prescribed for a work-related injury, then heroin when his father died. He blew the $73,000 insurance payout on drugs and a $41,558 Land Rover, which he drove when selling $225 worth of drugs, 2 grams of heroin to undercover police officers. Tim's vehicle was seized and kept, which amounted to a fine more than 184 times larger than the sum involved in his offense. Come Wednesday, the U.S. Supreme Court will hear arguments concerning whether this violated the Eighth Amendment, which says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Emphasis added. The seizure was done under Indiana's version of civil forfeiture laws, which allow governments to seize property used in the commission of a crime. As they are often used, such laws are incentives for abusive governments, because the entity that seizes the property frequently is allowed to profit by keeping or selling it. Lucrative law enforcement will become lawless. Under the incorporation doctrine, the Supreme Court has explicitly applied, through the 14th Amendment, most of the Bill of Rights protections, piecemeal, against states' behaviors. The court's standard for doing so is whether a particular provision of the Bill of Rights is deeply rooted in the nation's history and traditions, and is fundamental to our scheme of ordered liberty. The Cruel and Unusual Punishment Clause was incorporated in 1962, the Excessive Bail Clause in 1971. The punishments provision protects Americans' bodies, the bail provision protects their freedom. The fines provision is intended to protect their property. In a 1989 case, Justice Sandra Day O'Connor sensibly wrote that there is no reason to distinguish one clause from another for purposes of incorporation. But although 2 federal judicial circuits and at least 14 state high courts apply the excessive fines clause to the states, and although 7 times the court, or 2 or more justices writing separately, has said that the Eighth Amendment as a whole applies to the states, it has never had an occasion to explicitly apply the excessive fines clause. This allowed Indiana's Supreme Court to be permissive regarding the state's forfeiture practices. The court unanimously rejected Tim's argument, that of the trial court, and of the appeals court. In a hearing on the state's civil forfeiture request, the trial court said that making Tim's forfeit his vehicle would be grossly disproportionate to the gravity of his offense and hence a violation of the excessive fines clause. The state's Supreme Court, however, held that the U.S. Supreme Court has been insufficiently definitive. The Indiana justices said that although our colleagues on the Court of Appeals and the trial court may be correct in foretelling where the U.S. Supreme Court will one day lead on whether to apply the excessive fines clause to the states, until the clause is unambiguously applied, Indiana fines can be grossly disproportionate without violating the U.S. Constitution. Indiana's Supreme Court insists that the U.S. Supreme Court is guilty of a lack of clear direction regarding incorporation of the excessive fines clause. Presumably, the U.S. Supreme Court accepted Tim's case in order to explicitly give nationwide force to one of the few remaining provisions of the Bill of Rights not specifically incorporated. It is about time. 9 of the original 13 states had equivalents of the excessive fines clause because they recognized that economic sanctions can be as punishing as incarceration. The 14th Amendment changed the relationship between individuals and the states, establishing that state borders should have no bearing on federally protected rights. Indiana purports to want constitutional specificity regarding excessive fines. It will have it by June. In determining when fines are excessive, courts must adopt something akin to former Justice Potter Stewart's famous axiom concerning pornography: you know excessiveness when you see it. Justices who fancy themselves originalists should acknowledge that those who wrote and ratified the Bill of Rights understood that courts were going to have to give content to the concept of excessiveness, as well as to cruelty and unusualness in punishments, and unreasonableness regarding searches and seizures, and other open-textured constitutional language. Doing so is not judicial activism, it is judging. Failing to do so is a dereliction of the duty to enforce constitutional guarantees. Washington Post Writers Group. George Will's email address is georgewill@washpost.com. George Will.
Hey Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.